Morning, everyone. I'd like to thank you all for coming to our first breakfast seminar of 2010 in the new decade. Today we have a question and answer format, and it's under the title of Just Ask Us, where we're going to take questions and hopefully answer them to the best of our ability. Our panelists today are Ann Worker and Jordan Ayton from our firm. Also in attendance today from our firm are Megan Connolly, Natalia Angelini, Christopher Graham, Rick Bickram, and Heather McGuinness. I'd like to welcome all of those, welcome you who are here today, and welcome to those who are listening in on the telephone and to those listening in by way of webinar. Our ranks from Hull and Hull are a bit thin today because many of our warriors are off in battle. Ian Hull and Susanna are in a lengthy matter that's starting in Toronto today, and David Smith is doing battle in Kitchener on another estate matter, and Craig Vanderzee is off before the Human Rights Commission, of all places, today. So we wish them well, and without any further ado, maybe we'll get started with some of the questions. I'll ask anybody here if they have questions just to approach the microphone and ask the questions. If you're calling in or on the webinar, you could email me, and I'll take your emails as we go along. In preparation for this, though, we've solicited questions from you, and we have a few questions. So maybe we'll start with the first one, which is an email from Gregory Brecken, and he referred us to a case of Ashton Estate and South Muskoka Memorial Hospital Foundation, and that's in the materials that we prepared for you today. And Greg writes, the case shocks me to the extent that it seems to say that where a will begins, I revoke all former wills and other testamentary dispositions, which we often see in our wills, and that the reference to testamentary dispositions revoked any prior RSP or RRIF designations. Greg found this a bit shocking. He thought that unless the will made specific reference to an RRSP or RIF policy and specifically revoked it, that the designation in the registered plan would prevail. I'm not certain that the same would hold true with respect to life insurance policies, and he asks for our comment and opinion on the case that he found quite alarming. Just to summarize the Ashton case, that's a decision of Mr. Justice McIsaac out of Barrie. In that decision, he went over facts wherein the deceased owned an RRIF. In 1998, he executed a specific beneficiary designation that benefited his 8 children equally. Later, in 2001, he executed a will that provided for his 8 children, but in differing percentages, so they each received a different amount under his will. The will, in his will, he had the normal revocation clause that says that he was revoking all prior wills and testamentary dispositions of every kind and every nature and kind whatsoever made. He didn't specifically refer to the RIFs or his other investments outside of his will. Now, the court was asked whether this general revocation clause canceled the prior beneficiary designation, and the court held that it did. The RIF, therefore, that was the biggest part of his estate, essentially it was 95% of his assets, passed to the children under the will, so that it would pass to the children in unequal shares, as opposed to the RRSP designation, which was equal to all. And he wants to know what our comments are on this quite surprising case.
It's wrong. But I'm not a judge. But I think it's a wrong decision. He relies on a Court of Appeal case, Lapshova, and he relies on it in an incorrect way. And when I first read this case, when it came out last year, I said, I'm going to ignore this. I just thought this is totally off base, because the implications of this case means that the financial institutions would have to get a copy of to make sure there was no will after the designation. So in this situation, you have a designation and you have a subsequent will. It's got boilerplate, I hereby revoke all previous testamentary dispositions. The Succession Law Reform Act allows a financial institution to pay to whomever they have on record. So the financial institution will get worried because they'll say, well, if there's a further will that revokes this previous testamentary disposition, then I'm in trouble. So I think this case is problematic on so many different levels. I think, furthermore, if you think about it, if the judge thinks it's a testamentary disposition, then why wouldn't the anti-lapse provisions prevail? Why would it not be revoked on marriage? So saying that in a general way, it's a testamentary disposition and revoked by this boilerplate provision in a later will, is really troubling. And I'm not saying it's not a testamentary disposition insofar as a beneficiary designation, but I think we have to tease out testamentary disposition in what context. So often the cases talk about it, do you need capacity? What kind of capacity is required to make a beneficiary designation? So in that situation, it's testamentary, and that's a standard of capacity that we're going to use. Interestingly, you may remember 2003, we had that case Amherst Crane. And Amherst Crane, there was a big hullabaloo about whether there was creditor access to RIFs and RSPs after death. And there was a lot of discussion in that, or a lot of scholarly interest in whether if it was a testamentary disposition, the RSP, then it fell into the estate and it was subject to creditors' claims. Well, our Court of Appeal decided that it was not subject to creditors' claims. So in that context, the RSP was not a testamentary disposition, or is a testamentary disposition in a very weird way. So by way of answer, I think I agree with the person who asked the question, and I'm sorry I've forgotten his name now, that it's a very problematic case, and I know Jordan has some thoughts on this too.
I'm not as brave as Anne, so I don't ignore the case. So what I've done is, I agree it's wrong, but I don't want to be the I don't want to be the drafting solicitor on another case that's wrong. So what I've added into my revocation clause is simply, and I'm just looking at it right now, is I revoke all former wills and other testamentary dispositions, and then I put in parentheses, which for greater certainty does not include designations made pursuant to Part 3 of the SLRA or the Insurance Act. So hopefully that will get around the Ashton case. This is a problem with the case. It's probably wrong, but we can add a few words and hopefully solve that problem.
So the common thinking then used to be that you had to specifically refer to the RRSP in order to revoke it.
Well, the legislation does say that.
Yes.
But don't let that bother you.
And you're saying specifically say that those designations are not revoked as
Correct.
A way to get around this possibly problematic decision. From a litigator's point of view, having that case in our arsenal is just another matter that we should be reviewing with clients. If they come in and there's RRSP designations, it may be that they are revoked, and we can rely on this case to go after those.
Right. The legislation talks about a change in designation or revocation. You have to refer to the plan either specifically or generally, is what the legislation says. So I guess
this is the most general.
That's the most general.
Yeah.
And I actually don't think you could rely on it, because I would, if I was acting on the opposite side, I'd pull out Lac Chauvet and I'd point out all the things in our Court of Appeal, what they said, and among other things they said, whether the statutory prerequisites necessary to implement the intention were met in the will. So there's other things in the Lac Chauvet case, which things like assume for the sake of discussion that the banks were presented with a deceased will and a demand for payment of the benefits under the plans founded upon designations implicit in the will. So interesting in that in the Ashton case, we don't have a copy of the will. So we don't say, I give all my property to my trustee. So then who goes to the bank to collect the RSP in the Ashton situation? Who or what is the object of those implied designations? To whom would the banks be obliged to make payment? To the estate? To the estate trustee? To all of the beneficiaries named in the will collectively? You see the problem that we have in Ashton. And there was one other thing. The Ashton refers to paragraph 9 of the Lac Chauvet case. That's the only reliance that he puts to say you've got a general revocation. And in paragraph 9 of Lac Chauvet, all it says is there was no. Let me just get that in front of me now. The will contained no revocation clause. So he says the opposite. Well, this will does contain a revocation clause, a very general revocation clause. So again, I don't think that you could actually rely on Ashton if you really push came to shove. If I was acting on the other side anyway.
And the judge seems to deal with the revocation in just two sentences,
in two
really.
sentences.
And it doesn't spend much time on that, and it may be something that we could distinguish if necessary.
I hope so, because there's a lot of wills.
Yeah.
There's only probably, a million.
And all of them seem to have that
have
clause.
that same revocation clause.
Crazy case.
Another question, and before we go any further, if you do have a question, please feel free to jump in with it. But if there aren't any questions yet, I'll take another question from Gregory Brecken. His second question also relates to RSP designations. And he says that in second marriage situations, sometimes you see an RSP going to the second wife and the residue of the estate going to children from a first marriage. His concern is that if the spouse who gets the RSP does not roll it into her own RSP, or doesn't make that election, it may be that she gets the RSP where the estate will be stuck with the tax bill. Is this understanding correct? And if it is correct, absent some marriage contract, can the testator somehow address in his will that the gift to the second spouse, the rollover of the RSP, is contingent on her agreeing to use the rollover so that the tax consequences aren't triggered? And what are your thoughts on that?
Well, just to back up for a second, the idea of an RSP designation to a spouse is that provided that they roll it into their RSP, there's no tax. Deferral of tax. There's no tax at that point. Yeah. And the other point that's important to this whole thing is that if there is tax on an RSP, that it's borne by the residue of the estate, not by the recipient of the RRSP, the designated beneficiary. So that's where the conflict arises. And then Anne will jump in with
a qualification.
Sure.
And the qualification is that if a spouse is actually designated as the beneficiary, so I'm not saying there's an election, it falls into the estate and they elect to use a portion of the estate to give to the spouse. The spouse is the beneficiary and they elect to have some of that money, the RSP that goes into the estate, go to the spouse. If the spouse is actually designated as the beneficiary, then she is a qualifying beneficiary and she receives the refund of premiums, which means that actually the RSP on death is not reported in the deceased tax return. It's reported in the spouse's tax return, and she gets a deduction for the amount that she rolls into her RSP. So that's the mechanics of it. The difficulty comes if you've actually got an unfriendly spouse, right? If you've got a friendly spouse, there's no problem because the spouse is quite happy to, particularly if she's the beneficiary, to defer the tax, report the refund of premiums in her return and roll it into her own RSP. I think what Gregory is asking, well, what if the spouse doesn't report the premiums in her own RSP, and what do you do then? I think then, I actually haven't had a situation like that. I haven't actually had to fight about it, but I have taken calls from tax preparation people. If you have to fight with a spouse, often the problem can be getting the slip from the financial institution issued in the right name. But if you look at all of if you go on the CRA website and you look at the IT bulletin and you look at the other things, it's actually the executor's decision to decide how much gets reported in the deceased tax return and how much gets reported in the spouse's tax return. And if you look at 146 Section 8, I don't recommend trying to call that up on your computer because it's such a huge file.
I was just doing that.
You can't move in it at all. It's impossible. So you won't be able to. It's just so. Anyway, so look at 146.8 of the Income Tax Act. And I think that if you're acting for an estate trustee and the spouse is the designated beneficiary, I think you should stand your ground that she should be reporting the tax in her hands, even if she refuses. And it's going to take some negotiations at first because you're going to have to deal with the financial institution often may issue this first slip in the name of the deceased. It's getting the slips, and you may have to talk to Revenue Canada. But I think that it's up to the spouse to report the tax if she is a designated beneficiary, which is different than if it falls into the estate.
If it falls into the estate and the will bequeaths that to the spouse, is it the estate that's responsible for the taxes in that situation?
It is, unless they jointly elect.
Now, can the will provide, or is there some mechanism for requiring that the spouse make that election?
Yeah, I think that you can make the gift of the proceeds of the RSP. Now, you're going to pay probate tax on that, right? And that's the issue. If you want to have some control over that RSP, you've got to have it come into the estate, and you're going to have to pay estate admin tax on it. Once you do that, then you've got full control over the proceeds. You're going to collect it from the financial institution, and you're going to take control of it. And then you can say, you know what, this is the condition for you to receive this money. And then you can have her sign some undertaking, you can get some direction, that's the best plan in that situation.
Yeah, so I think, just to answer the question, I don't think it's as big an issue as he thinks. It might be if the spouse just says, well, I'm not going to roll into my RSP, because really the spouse, it's going to cost the spouse more than it's going to cost the estate.
Right. And there's a way of providing for that by making her gift contingent or conditional
If you're going to do it through the estate.
through the estate.
Yeah.
Okay.
I think the same goes with, sometimes people want to make sure, well, I want it to go to my kids afterwards.
Yeah.
And I don't, that's kind of like trying to have your cake and eat it too. And I think if you want to get the deferral of the tax, then you're going to have the registered plan go to the spouse and have her put it into her own plan. That's the only way you're going to get the rollover, is if she reports a tax, takes a deduction for the amounts that are contributed to her own plan. There may be some side agreement or side contract which requires her to, there's got to be some quid pro quo there, requires her to make the children the beneficiaries. I think the enforcement of those types of arrangements is very difficult.
So then, how do we, this is a problem that I struggle with, because we can't really do a trust. We can't do a trust. If it was any other asset, we'd give it to the spouse during their lifetime, and then we'd say, with a remainder to my children. But to date, we still can't do a trust. Is that right?
I don't think you can. I don't think you can defer the tax and do a trust.
So what kind of advice then are we giving our clients about that? Because that's a common. Sometimes the RIF is the RIF is the biggest asset that it has to provide both for the spouse and wants to provide for their kids on death. What's your advice?
Well, I like to hedge in that situation. Give half of it to the spouse and give half to the estate, or do some way that you can get half your deferral. Try to get half of one side of the action and half the benefit on both sides, but you're not going to be able to get 100% of the benefit on both sides. That would be my advice in these circumstances. I find the side, I think Rick actually has had a case where there's been ongoing discussion about how to settle this a kind of a trust that was tried to put in place with a connection with the RIF. And there's been a lot of going back and forth between lawyers about how to settle that dispute and that side agreement and enforcing it, all those issues.
I do know that the CBA, Trust and Estates section, so the national section, has been working to try to get some legislation in place that will allow some sort of trust for RSPs and RIFs.
Like the disabled, like a qualifying annuity or something like that.
Yeah. So, but to date, we're still stuck with that problem.
Okay.
So there may be a better answer down the road, but we're not there yet.
Yes.
The next question comes from Yeti Agnew. He says, what are the issues to consider when considering designating a beneficiary of a life insurance policy as trustee for children, minors and beyond the age of 18, especially where parents of the children are separated or divorced and the beneficiary is not a parent, meaning the person who's receiving the funds for the minor is not the parent. We often see insurance beneficiary designations that say it goes to X in trust for the minor.
Nice.
What considerations or concerns does that type of beneficiary designation raise?
Well, obviously it's a problem because the trust has no terms, and the insurance institutions, their forms just say name a trustee for the minor children. Well, that really doesn't solve the problem. So you have to do or you don't have to do, but what I would recommend, and what I do is I do a separate insurance trust. I designate, if it's not the parent, that's fine. It doesn't have to be the parent. Set out the terms just as if it's like you would in the will. And I do that in a separate document that follows the will. It's signed independently. And whatever the terms are going to be, if you're going to hold it till 25 or pay it over stages. The good thing about insurance is that, unlike an RSP, we can set up trusts. We can put in a trust for the spouse during their lifetime of the proceeds, and then gift over to the other children. So there's a lot more flexibility with insurance, and insurance trusts are really, important. If it's not going to fall into the residue. So if it's a small policy, if you're not so worried about estate administration tax or creditor proofing, then you can just have it fall and designate the estate as the beneficiary, and it goes into the residue. But once you're trying to avoid some probate fees, then you got to do your work again. You got to set up that trust in detail and explain how that's going to work.
If you don't set up that trust and you just see the insurance beneficiary designation naming someone with a trust, what powers would they have to deal with the monies?
I think they have to pay it into court. I'm not sure what I mean, technically, they would have it till the kid turns 18 with no power to encroach, and then at age 18 they turn the whole thing over. Do you agree?
Yes, I do.
So the better route would be to just pay it into court to the benefit of the child, and then the child's guardian or parent can make fiat and apply to have some of those funds released as needed.
Right.
So.
Great, thanks.
Yeah, I agree.
The next questions come from Stephen O'Donoghue, and he asks two questions relating to passing of accounts. He gives an example of where there is, for example, 6 residual beneficiaries of an estate, and all 5 of them sign a release, but the one holdout refuses to sign the release, forcing a passing of accounts. Do the 5 who have signed releases in that circumstance have any standing to object at the passing of accounts?
Anne, do you want to do it, or shall I?
Yeah, no, okay. I think you'd have to, I think they would have standing, and I think that any release, if you wanted to kick them out of the box, your release would have to have been iron tight. So your release would have had to have attached accounts in the same format that are before the court. All legal bills would have had to have been reviewed by the beneficiary. They would have had to have had legal advice. So if there was a lot of ongoing discussion before accounts were passed and all sides had lawyers and they went through everything tooth and nail and their objections and they resolved, and as a result of that they signed a release, and then at the passing of accounts they start to raise all other issues, I think that there might be cost issues that they would be really vulnerable to, or the judge might say, no, that's been dealt with, you're just trying to reopen things. But if you've got a usual kind of standard release that a lot of lawyers send out to beneficiaries and without the benefit of legal advice on the basis of informal accounts, without seeing the legal bills, I think that beneficiary will have no problem making objections on the basis of the accounts that are before the court.
Yeah, and likely what you've done is you've set out a distribution schedule for what you're going to be getting, and they sign off on that. And then if you go through a passing of accounts, there's going to be additional fees, et cetera, et cetera.
They didn't agree.
They didn't agree to those. So I think they would have some standing to deal with those issues if they're not getting what they thought they were getting when they signed the release. There is certainly, I don't know if this is part 2 of the question, but there's certainly case law that says if you've got an objector who's just objecting for no good reason and they're just trying to be difficult and their objections are not sustained, that they are liable for costs. And not only will they not get their costs, but they may be liable for others' costs. And there's a case called Bedont, B-E-D-O-N-T, where that was the situation. They said they had one objector, everybody else was fine with it, and the court said, look, none of your objections were worth raising, and we're going to see that you pay some of those costs.
Yeah, and that's the second part of the question is if the 6th beneficiary who does cause the passing of accounts by not signing a release and he has no real reason to object to the accounts, but is just being difficult for whatever reason, relying on Salter and Salter estate, which is an estate litigation costs decision, or any other principles, can you obtain an order against the rogue beneficiary for costs of the passing? And that's the lesson we've learned from Bedont.
Yeah, and in fact, just so you know, in that case, the objector had to pay complete indemnity costs to the estate trustee in the amount of $28,470. And the site for that is 8 ETR 3rd at 151. Nope, sorry. Let me get you that site. I will get that for you in a second.
So I think from that case, it's clear that you're not required to consent to the accounts, and you could require the passing. But if you do raise objections that are not sustained or that are unfounded, in that circumstance, you may be found liable for costs.
The cost decision, because there's a bunch of them, the cost decision is found at 9 ETR 3rd at 67, page 67.
John, there's another case, Rooney versus Stewart, which is some authority for what I had said at the first part of this question. Rooney versus Stewart. I don't know if you can find it.
The Rooney decision deals with releases. I think releases were signed by beneficiaries there.
Yeah.
However, they didn't have full disclosure. They weren't given the solicitor's accounts or a breakdown as to how compensation was claimed, and the court there felt that the release wouldn't stop the parties from proceeding to question the accounts. Okay. A question now from Bruce Farnell. He asks about probate applications or applications for a certificate of appointment and whether they're subject to a transaction levy.
I hope not.
Well, you know, it had always bothered me, because I could never find, when I kept on looking in the Law Pro policy, and of course, there's nothing in the policy about it. So I emailed, this was in 2006, I emailed Law Pro, and I said, you know, I've got a bit of a problem here. I want to know what the situation is as far as certificates and non-contentious passing of accounts. And they wrote back to me, so I've got it in writing, we confirm that the transaction levy does not apply to non-contested application for a certificate of appointment nor the uncontested passing of accounts. And then she pointed me to the endorsement number 3 of the policy, which doesn't even have any of those words in there at all, like not even close. So, but at least I do have it in writing, so if anyone were to ask me. So I think as soon as you have an objection that's filed either on the accounts or on an application for a certificate, then you have to pay your transaction levy. So I replied, of course, please consider whether the endorsement should be amended to expressly allow for these exclusions. Well, I never got a reply for that. Anyway, there you go.
You know what? I learned something right now, because I've been paying my transaction levy on passings of accounts. So there you go.
Non-contested.
Well, yeah.
Well, there you
as soon
go.
as I issue the
When you
application.
issue the application, you're not
Yeah.
sure if it's contested or not,
Yeah.
so you're paying it.
I don't know if anybody else is making the same mistake, but there you go. And it's on tape. So.
I got an email. I got it in writing.
You'll email that to all of us for future use.
I wouldn't have dared otherwise.
Bruce Farnell also raises an interesting question with respect to proceeding to sell real estate where you don't have a certificate of appointment. The estate trustee can escape probate for first dealings with real estate, but funds generally come back to the law firm, which are then distributed to the estate trustee, resulting in a substantial bank account exceeding the bank's threshold, so that probate is then required in order to deal with those funds. He asks whether there's a way of dealing with that by having the money come into the lawyer's trust account. What risks are there on a solicitor who is acting in a real estate transaction for an estate where there's no probate? Are there risks that a solicitor should be concerned about? Are there risks that the estate trustee should be concerned about? Are there risks that a purchaser should be concerned about? All those risks that arise where there is no certificate of appointment.
Well, I'll do the easy one. There's no risk on the purchaser. Buying from an estate trustee when there's a certified transmission application on the Land Titles Register. So Land Titles Act, it guarantees title. And if it turns out, of course, if you don't, you know that if your property was originally registered under the Registry Act and it's a first dealing after conversion to the Land Titles Act, then you don't need a probated will. You can tick certain boxes off and send a covenant to indemnify the land titles fund, indemnity fund or assurance fund. Now,
And that's the estate trustee who's giving that indemnity.
that's the estate trustee who gives that indemnity. So I think if someone comes along and says, well, actually, I have a subsequent will and the house really belongs to me, then the real beneficiary will get would they be able to go to the
Compensation
they'd go
fund.
to the compensation fund. But what happens to the lawyer who then sells that house on behalf of the estate trustee? So the lawyer takes their direction from an estate trustee who does not have probate. And if the lawyer takes a direction, and at first I thought, well, the lawyer's just taking direction from the estate trustee. Why is that? They're just the agent, they're the client, they're not the mastermind in all of this. But then I thought about it a bit further, and what was it, Section 47 or Section 48 that we looked at?
I think it was 48 of the
48
Trustee
of the
Act.
Trustee Act. I always get them a bit too confused, but one of them, it's the effect of a revocation of an erroneous grant. And basically that section says that anyone who makes payments to or by or to from or to an estate trustee who has probate is protected. But if you make payments to or from an estate trustee without a probated will, then you do not have protection. And so I thought as a lawyer, maybe actually you have some liability from handing over funds to an estate trustee who does not have probate. And I hadn't really thought about it before, so I was glad for the question, actually.
Yeah, Well, there's a couple of risks. What about the purchaser who relies on a direction signed by an estate trustee to pay the funds to A, B, and C, or to their solicitor and trust? I mean, do they not have that same issue?
I don't know.
Potentially. I mean, one option I think the person asking the question wanted some options. I mean, one option, I guess, is to have the estate trustee, if he's going to distribute the funds, is to just have the direction payable, split the funds, or the proceeds of sale to the beneficiaries right on the direction proceeds. So that it goes directly to them. But the other thing is, I would say, is go to the bank, say, look, you haven't required probate for this account. I'm telling you, I'm going to open up an estate account in my name, but I'm telling you, funds are going to go in and come out, but you're letting me open it, and you're going to say it's going to be okay for me to withdraw them as well as deposit them. Or another one is you open up an account, and you'd have to think through this a little bit, but in the estate trustee's name, where legal title is in his name, but he's the trustee of that money.
The bank will require, then the bank may require some kind of probate document to get the money out. And so I guess it's really getting some comfort with your client, and knowing if it's someone you know, whether it looks like you have to get some comfort from the type of will that it is. Does it giving everything, does it look straightforward all to the kids? Are there any kids cut out? You'd have to take a look at that, and I'd want to make sure that I had some comfort with the facts. Thank goodness I don't do transfers residential real estate in that situation. I'll do the transmission application, which is no problem doing that, but the sale is something else again.
I think there is,
Yeah.
I mean, we talked about this a little bit, but we thought that there was some risk there for the solicitor, potentially.
Remote, anyway, yeah.
Remote ones, but it's still a matter of knowing your client.
Paul, Bill Whitaker, why not convey to the beneficiaries and then the beneficiaries convey to the ultimate purchaser?
I'll just repeat the question.
To the beneficiaries would be an estate conveyance, no land transfer tax aspects. And then you get around the problem, wouldn't you, that you just outlined?
It would be subject to the debts of the estate, I guess, because if the beneficiaries are transferring within 3 years, right? Yeah, I guess then you're not, that's a good idea.
No, please do.
Yeah.
We struggle with this one.
Monopolize that.
No, we struggle with this one, yeah.
The question's somewhat related. Is there any standard practice developing in terms of waiver of probate? Because the banks seem to be all over the place. Any amounts, for anything from 10 or 15,000 to, believe it or not, $750,000 I've gotten waiver of probates on. One thing I
Lucky
find
you.
is that the brokerage firms, even though they're related to the banks, you just can't move them off wanting probate. I'm just curious whether there's any commonality developing.
There's no commonality that I've seen because it's on a branch by branch almost basis. Again, as you indicate, there's relationship between the deceased and the bank that goes into it, the amounts. And I agree with you. If you're trying to get an investment portfolio transfer without probate, if you can do it, you're a better person than I.
I think the broker has to personally takes a personal risk when they do that without probate, and they just don't want to do it.
And why would they? I mean, if I were a bank, why wouldn't I insist on probate every single time?
Are banks accepting indemnities from trustees or beneficiaries, and is that?
If it's a small enough amount, and they knew that it's all going to the spouse, and or they knew the testator well, things like that. But they're not in the risk business.
And just another administration-related question. I find now that when you write off to a bank or another depository, they come back at you citing privacy legislation. You as a lawyer writing.
Doesn't it drive you crazy?
And what they want doesn't make any sense because there's no proof of any bona fides in terms of.
Yeah. Do you know what I'm doing now? When I first on estate administrations, I used to go in, get the will, everything. At that first meeting, I asked them to sign a direction to release information. So when I send out inquiry letters, I've got the direction from the named estate trustee allowing them to release information to me. It's just another step another piece of paper, and that usually smooths that along.
Just on that question, what is the actual problem when you're
They
trying to get
don't,
balances?
you say you're the lawyer for someone, they say, well, sorry, we can't release information to you because you're not the estate trustee. So you say, even though you say you're acting for the estate trustee, they won't release information to you without a direction from the estate trustee to release. All you want to know is the value of the bank account at death or something like that.
Right.
And sometimes, of course, you have people saying they're not going to release information to you without probate, which is particularly absurd.
Yeah, yes, that's
but
good.
that, usually you can boot up that problem pretty quickly, I mean, by just taking it one step higher. Yeah.
Okay. Any other questions? Okay, back to our emails then. Bruce Varnell asked another question. He asks, what are others doing with real estate sales and debts and the need for a court order if the transfer is to a beneficiary to be free of debts until a lapse of 3 years from death? Are all parties accepting that and getting court orders where required, or are they doing the statement lands not subject to debts? And if so, on what authority? I expect that you should not take a declaration from the estate trustee as to debts as being sufficient.
Well, I'm not a conveyancing lawyer, so I don't have real experience with this.
I have some comments. If you look at the Electronic Registration Procedures Guide, there's absolutely nothing in it about Section 17 of the Estates Administration Act, which talks about the powers of executor to sell land and whether or not it's subject to debts. And it's all very complicated, but the net effect is that if you transfer to a beneficiary within 3 years, that land is subject to the debts of the deceased. And so normally when I've got a situation like this, I say, listen, if you're not sure whether or not you're going to sell this land or if you're going to keep it, then keep it in the name as the estate trustee and sell it as estate trustee. And I'm talking about a will that has a power of sale or an implied power of sale. And then there's no problem. You can sell that land. It's never subject to debts. So I think that even if you do tick off boxes when you do electronic registration and say, yes, the land is not subject to debts, which most of us do, I think if there was a claim that came after the fact, a creditor who came, that land would be subject to the debts of the deceased, and so you would have to advise your client accordingly. So that's one very important thing. Purchasers who buy from a beneficiary within 3 years, so as a lawyer acting for the purchaser, if you're buying from a beneficiary of an estate within 3 years, you would have to be really careful because you actually become liable. That land still, within that 3 years, is liable for the debt. So if there's been no claim within 3 years, the purchaser takes it, in good faith, takes it in no problem. But if the purchaser buys within 3 years, then that land is still subject to debts. So it is a very risky thing to do, and you have to advise your clients accordingly. Electronic registration and saying the land is not subject to debts, or it is or it isn't, it may just, that may, and in some ways, if I know there's no debts, and I've got some affidavit or something from my client to say there's no debts, and I wouldn't have a problem saying the land, I don't know, I guess I would. He says, on what authority am I ticking off the box, solicitor statements? I don't know on what authority that I guess it is. You would have to say it, I guess strictly speaking, you'd have to say it's subject to debts. If you're transferring to a beneficiary within 3 years, you would have to tick off the box that it is subject to debts. I did one where I knew there was a big CRA liability, and I also said it was subject to debts.
And they still bought it?
Well, it was the co-owners. There was a big hullabaloo. The co-owners bought it. So that's the answer to that one, Bruce. Hope you're there. Are you here, Bruce? Oh, well.
Thank you. There's been a number of decisions by Mr. Justice Brown and others relating with the day-to-day administration of the estates list. One of them deals with communications with the estates list by email, and that's the Reed Charles estate. Can you comment on that?
Well, if anyone has experience dealing with the Toronto Estates Office, they know it can be challenging. So what Mr. Justice Brown says, I think the case was somebody tried to do something by email with the court and emailed them some information.
Right. I think they applied, and there was that pre-printed form that they checked off
No, there were
boxes.
huge delays. It would look like 2 years late. Mom would write one letter, and then they would write another letter. So it was like 2 years would go back. But I actually thought it was quite a hilarious case to choose as an example. Say we should use email, because in that situation, the lawyer took like 6 to 8 months to respond to this other. I mean, we call it snail mail, but that was like really
It's
ridiculous.
one of the few recorded decisions that actually refers to snail mail.
Snail mail.
I think
So I
Canada
thought
Post
that-
is appealing.
So I thought that was kind of a funny decision to choose. I think the correction notices are usually inscrutable anyway, so I've actually got to know most of the corrections you could possibly do, so I kind of know their code now. But I don't think if you get it by email or by regular mail in 2 or 3 days, I actually don't think it makes a huge amount of difference myself. But I'm a bit of a old-fashioned maybe.
But in
You're a
that case,
snail mailer
they
yourself.
Well,
refused.
it's the content, not the mode of delivery, really, ultimately. So.
Right, but I think the court refused to deal with the fact that it was the corrections were sent by email or the explanation was sent
Do we
by
have it
email.
here? No, we don't have it.
And finally, Justice Brown said, "Look, the court. I'm directing the court, I guess, the estate's office, to deal with solicitors and the public if the inquiry can be dealt with through email, to deal with it by email." Well, that seems like a pretty sensible
Yes.
solution. And it has not been appealed, I guess. Is that?
No, not that we're aware
I'm
of.
not surprised. I'm not surprised.
The issue of costs is always a concern when matters proceed through litigation, and we have the Salter decision that we referred to earlier with respect to costs in estate litigation matters, and how just re-emphasizing that costs won't come out of the estate. The estate won't be seen as an ATM machine. With respect to the issue of costs in guardianship matters, though, what guidance is there from the courts on costs where guardianship matters are concerned?
Well, I think Justice Brown is particularly concerned about the idea that you're going to name your parent as a respondent, try to get guardianship, and there's going to be a fight between you and your siblings, and that Dad's going to pay all the costs of all the fighting siblings. So that is, I would say, except in rare circumstances, not going to be the case. Certainly, if Justice Brown is your judge, because his view was, and I think it's correct to some degree anyway, at a minimum, that Dad is not going to pay so that the kids can thrash out their historic jealousies and guilt and family troubles through the courts. And if the true interest of a guardianship application is only the best interest of the incapable person, then you'd better be looking like the person who has that best interest in mind when you're a litigant. Because otherwise, if it looks like it's just a so-called pissing match, then you're not going to get costs. And excuse me. And these are, very often people come to all of us, I'm sure, saying, well, we want to fight for guardianship and et cetera. And then you have to say, well, okay, you're going to pay it. It's personal. If you want to fight that bad, then it's going to come out of your pocket. And that sometimes can put a damper on things, I find, because these are so expensive. They're really horrible litigation, and they're very expensive. And hopefully, rather than spending $50,000 aside, you can use that money for Dad's care and come up with some solution. Yeah.
Yeah, and then the courts are going to look very closely as to whose benefit the litigation was for and whether there was any real benefit for the incapable person. Mm-hmm. And the case on that is Fiacco and Lombardi in 2009, Canley 46170, that dealt with the issue of costs in that sort of match.
Yeah, in a will challenge is, I think, slightly different because it's an in rem decision. Sort of, the court has some inquisitive powers to make sure that only valid wills are probated, and therefore the right to object to a will and say prove that it's valid. Maybe some of those costs should come out of the estate, but in a guardianship application, it might not be the same sort of public policy reasons.
Right.
They are subject to mandatory mediation as well, right?
Yes, in
guardianship
Toronto.
disputes.
Yeah.
Has anyone ever tried to get a motion to dispense with mandatory mediation to keep the costs down? Or it sounds
No,
strange to
I-
say that actually now, because mediation used to be to
It's designed to keep costs
go
down,
but
often it's seen as just an extra step
an
in the
extra
proceeding.
step. So I was wondering if anyone's ever. Have you
I haven't. In fact, I think that mediation works well in a guardianship application, because everybody has to sit at the table and say, we are here. Do we all agree that we're here for Dad's best interest? Well, everybody has to agree in a guardianship application. I mean, if they don't, then they're not going to, right? So I think that mediation does make some sense, and maybe more so in a guardianship application than anything else. But
Although on that point, I was in court earlier, and the judge felt that the parties were just so entrenched in their position and so far apart that he didn't feel that mediation would be a useful step.
Oh, so he did order
it. And dispensed with mediation in that case.
Okay.
was it a guardianship application?
That wasn't. No.
Yeah.
With respect to applying for certificates of appointment, a number of issues arise. Perhaps you can comment on where you should be bringing those applications, and following from that, if you find the right place to bring the application, what issues arise where there are multiple wills, and what does the court need to be satisfied of with respect to multiple wills and the revocation clauses with respect to multiple wills?
Well, the first issue about where do you apply for a certificate of appointment is quite simple. It's where the deceased last was residing at the time of his or her death, the county in which he or she was residing at the time of his death. That is unlike applications, for example, to pass accounts, for directions or anything like that, which can be brought pretty much in any court.
Right.
But a certificate of appointment application has to be brought in the jurisdiction where the deceased was living.
And if you're challenging a will, or the outcome of your proceeding will be the granting of a certificate of appointment, that needs to be brought in the jurisdiction where the deceased resided.
Yeah, I would do that for sure. Unless you don't know where the deceased resided. I mean, that's sometimes the case as well, and you don't know where they're going to file the application for certificate of appointment. Dad was in a nursing home, but he still had a house, and you don't want to get caught up. So sometimes you have to file it in multiple places. Sometimes I might just file it in Toronto as well, because I know that will stop. That will get into the computer quickly and will hopefully stop the issuance of a certificate of appointment.
Okay. And with respect to multiple wills, there's difficulty where there's multiple wills and the one's being probated and the other isn't, and the court needs to be satisfied that that will that's being probated hasn't been revoked by the other will. How do you address that issue?
It's funny, there's this case that came out called Kerzner, K-E-R-Z-N-E-R, and that's one of Justice Brown's decisions as well. And in that case, he talked about multiple wills, because the court office, the Toronto court office, was a bit confused about how to deal with the application in that particular situation. What Brown said in that decision is, I want an affidavit to say that this will that's being probated hasn't been affected, or there's no impact on this will by the will which is not being probated. Funny enough, when you look at the application itself, you may remember that one of the statements in the affidavit says, I know of no other will that affects this one, or no has revoked this one. Does anyone know the exact? Anyway, it's in the 71 of the forms. So you actually have already said that statement. There's no other document out there that affects that will. So what Brown has actually asked for is an I really mean it affidavit. So I mean it when I said in my other affidavit there was no other document. I want another affidavit. And the reason, what happened is, if you look at the certificate itself, instead of the usual, this court issues a certificate to X, it actually says, upon order of the court, this court issues a certificate. So that's why the court wants, the court office wants a draft order, and they want a further affidavit in support of that order. And there was always a bit of confusion. When I've had them come back to me before, I said, well, why do I put in this affidavit in other jurisdictions in Ontario? And I had thought originally that it meant, well, what assets are in this will and what assets are in that will? I thought, well, that's kind of weird, because I want to keep the assets in this will kind of off the table. So I did a very carefully drafted affidavit about which assets were in that particular will that was being probated. And I got my order and I got my certificate. But Brown actually has said otherwise, so all you need, and I think if you've got your client, the estate trustee, who has signed your application for the certificate and has said that they know of no other document, I think you could do a solicitor's affidavit. You've looked at the two documents, and that one, maybe that's why they want someone to have looked at the two documents, you know, to say that the will A has not been revoked by will B, though most wills, you know, if you look at them, there's all different kinds of styles about how to do the multiple wills. In mine, I say I revoke previous wills. For further clarification, I'm not revoking this other one, just to make sure there's no confusion. But that's what's required. You need an affidavit and you need a draft order.
Great. One other question we had from Scott Blair deals with Henson Trusts and ODSP beneficiaries. He was considering a will that had a Henson Trust, which was a completely discretionary trust that seemed to be on side. However, the accumulations clause said that any income is to be accumulated but not longer than the maximum time permitted by law. Any accumulated income that is going to be offside of that will be paid out to the beneficiary. Mm-hmm. Does that type of wording take the clause, make the trust no longer discretionary, and put it offside? Does it confer a vested benefit on the beneficiary?
I don't think there's any problem. It depends on what age your beneficiary is. So if your beneficiary is 50, and that at age 21 years later, at age 71, they're going to be entitled to get income, then
Or maybe entitled to get
or maybe if there's
right.
any, then I don't think there's any problem with that. So I don't think the fact that it has to be discretionary for the period in which the person is entitled or wants to qualify for the ODSP.
And you can only get ODSP until age
And
65.
until
so if it's going to be paid out
yeah.
after that, it's not going to be a
It's
problem.
not a problem.
And
I mean, when I draft my Henson trusts, I do
Put other
not.
beneficiaries.
Yes, I put other
I do as well.
beneficiaries in the event that we hit the maximum, the 21 years.
I do as well.
I pay it out to somebody else.
Somebody else, or a choice, it's discretion between a
Right.
number of people. But I think that it's, that entitlement is at a certain, it's in the future, and they may or may not be alive at that time. So I don't think it's a problem from the ODSP standpoint.
And it may be that any accumulated income is paid out through other means, or is
Yeah.
paid out under the income cap that the
Yeah.
recipient's entitled to receive.
Yeah, they're entitled to $6,000 a year
Yes.
now. ODSPs.
Would you advise ODSP of the circumstance and give your opinion on the matter, or?
They're gonna want to see the
Copy of the
will,
will,
so
yeah.
they're going to look at it. I haven't seen that raised as a problem by ODSP, so I don't know if they what position they would take. I don't think they would. My guess
I don't
would be
think so.
they wouldn't
I
make a
don't
big
think
deal,
it'd
but we should draft it with somebody else.
Yeah,
if we
ideally.
can. Yeah.
Okay. Do we have any other questions? Just check my email. There's no email questions. So we're getting at, we're about 9:20 now, so perhaps, unless there are other questions, we have a question. Yes.
Bill Whitaker again. Just in terms of certificates and filling in the values, where we have many deceased clients today with assets in multiple jurisdictions, and I noticed that you're only supposed to include the value of real estate in Ontario, and any real estate outside of Ontario, presumably not. What about personality in terms of bank accounts elsewhere, realizing that an Ontario grant, you can clear a bank account in British Columbia or what have you. So there's a question of the value portion of on the certificate.
I think you should. I think your client has an obligation to report the value of the deceased estate, worldwide estate, except for land outside of Ontario. I think that's the rule. But how people actually fill in the two boxes, that seems to be...
I think it's clear that they have to declare that value of anything wherever it is located, except for real property outside of Ontario. I don't think there's any fudging there. I don't think.
Yeah, and even if it means you're going to have to actually pay a state administration tax or the equivalent of in two different jurisdictions, that's just the way it is.
That's why you would, if you have assets in other jurisdictions, you may want to have multiple wills.
Yeah.
So.
Yes.
Good morning, Christine Rusak. Now, this may be a simple question. I'm just getting started in estate litigation. So, acting for an estate trustee during litigation, what role does that estate trustee have in settlement discussions, in mediation, since they don't have, other than compensation, they don't, let's say that they're not a beneficiary?
It's a good question. What do you want?
There's a fabulous chapter in Schnurr's text on estate trustees during litigation. Just the best thing that's ever been written.
And who authored that?
Yeah, who authored that? I can't remember now, but
His name
anyway.
escapes us.
In that book, there's an argument that sometimes an estate trustee during litigation can be involved, and it's worthwhile to have them involved in settlement negotiations because they're seen perhaps as a more neutral party. Other times, it's really up to the other counsel, I think, unless it's going to be something that's going to affect you. For example, if they're contemplating that they're going to settle and they're going to have an order directing you as the estate trustee during litigation to do something like maybe transfer property, even though you might not technically be allowed to do that, you better be involved at that level. If instead they say, look, whenever we settle this, you guys are out and you'll just turn everything over to the estate trustee under whatever will's valid, then maybe you don't have to be involved as much. But certainly you're going to want to see what the terms of the settlement are, and you're likely going to want to, some input on that. But I don't think some counsel want you involved, and some counsel say we don't want another lawyer at the table to increase costs.
I think also if you look at this, if you're asked to sign minutes of settlement, you're acting on behalf of the estate trustee, and the parties are dividing up the estate, and there really isn't any consideration to the estate trustees, so you haven't yet dealt with your compensation, or they haven't yet released you for your administration, then there's no reason for you to sign those minutes of settlement, and there's no consideration. You may want to acknowledge them and say, yes, that's fine with us, or have some kind of, they may want some comfort letter, but I don't think you should be signing minutes of settlement and shouldn't be required to sign them.
I think the estate trustee during litigation plays an important role in gathering information and providing information to the parties, and is seen as often seen as a neutral third party in ensuring that the assets are there and accounted for, and so that the parties know what they're dealing with.
Now, what about someone who has been named in one will to be a estate trustee? The will is being contested, and someone else is trying to become the estate trustee. The person that we're representing, the original estate trustee named, is named as a respondent. What role does that person have? That person is not a beneficiary, and again, other than potential compensation for, being estate trustee, appointed.
Down the road, yeah.
What role?
Well, typically they wouldn't take a role. If there's somebody that is going to propound that will, in any event, the beneficiaries of that will are going to propound it, then typically what would happen is that executor would just submit his rights to the court, and that gives him certain rights to participate, but limits his involvement, and that would be it. And then when it's settled, he would get notice of that.
Okay.
But that estate trustee named in the challenged will could become involved and propound the will. However, there's cost consequences for doing that, or there may be adverse cost consequences if you're not successful.
Right.
Yeah. Okay. Thank you.
Thank you.
Good morning. Question regarding testamentary trust. The client has a few life insurance policies, some policies on his own life, and some policies on life of other people, his children, grandchildren, and other relatives. Upon his death, he would like the proceeds of his own life insurance policies on his life going to the family testamentary trust. At the same time, he would like the other policies that he owned on the life of other people also be transferred to this family testamentary trust. Is it possible to do that into the one testamentary trust, or should he create few trusts, and what is the best way to arrange that?
Well, I think it depends if he wants the same beneficiaries for both. For the proceeds of all of those policies, so the proceeds on his life, and then if the policies on someone else's life also go into the trust, are the premiums, are they paid up policies? I guess that's something you have to consider are the policies paid up how are the premiums on the policies on other people's life. They're going to be an asset of the estate, but they also have, as I said, they're only going to last as long as the premiums continue to be paid. So I don't think there's anything wrong with you having the same trust, but you have to consider how it's going to be managed if you want
Yeah,
the same
he leaving
beneficiaries.
proceeds of his death benefit is beneficiary is the trust, so it will be enough to pay taxes. And then when 21-year rule happened, so the policies that are not, still, in force, so what will be the effect of that?
The policies on who's, they're on his own kids?
On kids, on grandchildren, other relatives, so he wants all policies to transfer ownership upon his death to the trust.
Yes.
So trust will be the owner and the beneficiary, so he won't to continue with that. And
Yeah.
this is his legacy, don't give that to the children, just put it all in the trust, into the trust.
Yeah, I guess I wouldn't recommend it. Certainly, I'd recommend contingent ownership for when you've got policies on someone else's life. But if that's what he wants, then you've got a trust that's going to last for a period of time. But you have to consider how you're going to fund the premiums on those
Okay,
policies.
so contingent could be the...
Contingent ownership would mean that it's not part of the estate, but it doesn't mean you're going to give it to someone else,
Yeah,
and then
I
they're
know,
going to have the
yeah.
responsibility. It might make sense to actually give the policy to the person on whose life it insured and make them the contingent owner. So it's not quite like a beneficiary designation, but they do become the successor owner, and then as soon as your client dies, they become the owner of the policy and then have the right to decide who the beneficiary is going to be. And that makes sense. So they have the responsibility to keep the premiums up, but they're not going to get the proceeds until their death. So it does defer still the benefit of the insurance proceeds.
Okay, thank you.
I would
And
also want to talk to somebody
Yeah.
one of the insurance reps about how the insurance company would view a trust owning the life insurance and how they deal with beneficiary designations and things like that, just to make sure that it works from their side.
Yeah, it's okay with that. And I have a comment for the previous question was related to when RRSP is left in the will,
Yes.
okay, for the spouse. There are cases where the testator leaving maybe RRSP or IF for one child, and then he or she has the same value, maybe of a house, and leaving it to the other child. So it should be very careful, because the child who get RRSP or IF will get the full amount, and the other child who will get the residue of the estate will be responsible to pay taxes for
Yes.
this RRSP. So we have that cases, and I just want to mention that should be very
Yeah,
careful.
we have to mention it over and over
Yeah.
again because I think
Yeah.
it's a very important consequence.
Yes, another question?
Paul, Bob Gibson, just getting back to the issue of banks and indemnity agreements, a little concerned with the solicitor's liability when the executor comes to you and either they raise it or I raise it to avoid probate tax. The executor is signing an agreement saying he'll indemnify the bank. He receives the money, gives it to beneficiaries who are strangers. Then it turns out there's a later will going somewhere else, and the bank goes after the executor. And he's going to look to, I think, the solicitor, saying you should have warned me about that. And I'm just wondering, are there any cases really where you would advise somebody to advise an executor to accept an indemnity agreement rather than insisting on probate?
I think in a case like that where the executor isn't receiving the funds, then that should be our advice in most cases, is that you're running a real risk. You're collecting this money and paying it out to third parties, and you're staying on the hook for that. I think the indemnity agreement makes most sense where you're the executor and you're also the sole beneficiary, because you'll take that risk because you're receiving the funds there, and you can pay them back if necessary. But if you're a stranger to the estate in a sense, then yeah, I think you would be ill-advised to go on such an indemnity.
Well, I agree with Jordan. Sometimes when I'm talking to the bank people, when they tell me they'll accept the agreement, I tell them on the side, if I was advising you, you should be insisting on probate.
Right.
Just up to the bank.
I mean, in your situation, I would be saying to them, why wouldn't you get probate? Why?
no skin off your nose.
Yeah, what are you doing? you got,
Protects you.
yeah, like, oh, the beneficiaries say I can do this without probate. Yeah, well, they're not the executor. I'm not going to go on the hook for this. That means I'm going on the hook for this estate.
Right.
It depends, again, with your circumstances and how long it's been and, whether people have been thrashing it out and how, you're going to know what the situation is. But if they're strangers and you're not a beneficiary, then, as I remind my clients when they come in, the probate not only protects the financial institutions, it protects the executor.
Right. All right, thank you.
Yeah.
Okay, if there are no more questions, and we're just past 9:30, perhaps we'll adjourn our breakfast meeting for today. Thank you all for coming and for participating and for sending in your questions and asking your questions. We look forward to seeing you at our next breakfast meeting, probably in June sometime. I don't know if we have a date yet. But look for that, and it should be on our webpage and in our blogs and the probator that we're going to be sending out shortly as well. We're going to stick around for a little while longer. If you do have any more questions and you want to come up and ask any of us, then please feel free to do so. Thank you.